Good morning. Story time. I want to talk about a case, master hearing. We had a master hearing. We went to court yesterday. We had to enter our pleadings, and I want to talk about the case because this is a challenging case, okay? And I want to talk about it and, just provide some context to it and, some type of advice and, what's next for the case and stuff like that. Well, if you haven't done so, please go ahead and follow me on YouTube, because on YouTube we have extended versions of videos and we do have live sessions where we answer questions live, and you can ask your question and you can ask everything immigration related, so we can try to assist you. If you need a consultation and if you need to work with me one-on-one, you should basically consult, schedule your consultation. My consultation link is on my bio. Let's get right into it. Master hearing was yesterday, and we had to enter our pleadings. But first thing first, I want to talk about this. The manner by which a person enters the United States will determine whether or not that person will be allowed to adjust status in the United States through family, okay? Immediate family, of course. We're talking about marriage cases. We're talking about parent who's a U.S. citizen petitioning for a child under the age, or we're talking about a child who's a U.S. citizen over the age of 21 trying to petition for a parent who's a non-citizen. So those type of immediate family relative type of cases. Well, if you enter illegally, you cannot adjust status into without inspection. But if you're a parole, depending on what type of parole, you can in fact adjust status, if you provided that you're eligible for adjust status, of course, right? So this person into the United States. On or about September 18, 2022, she was apprehended, and then she was apprehended, arrested, placed into expedited removal proceedings, and then later on released on parole. The type of parole that you get, the 212 D5, the one that is for humanitarian reasons, or the type of parole 212 D5A, right, for humanitarian reason or public interest, that type of parole, the good one, the one that will allow you to adjust status. She was paroled, she was given paperwork and released. So now, and then placed into full removal. So we went to the hearing. When we're entering our pleadings, there were some allegations that were different from the actual parole, like contradicting facts. So we had to deny those allegations because those allegations are not pretty much what happened, right? So we had to deny those allegations, and we did not concede on the charge of removability under the paragraph that says that this person was not paroled. But the judge, however, sustained those charges. So we went back and forth, but when the judge make the ruling, the only thing you can do is appeal. So we preserve our right to appeal, and then we left the hearing. So here's the moral of the story. This is a problem that is happening at the border if you are released on parole, depending on what type of parole. Our parole is a good parole, so we have to fight for it. So we're going to file a interlocutory appeal. Simply means that we're filing an appeal prior to the final decision to let the BIA decides on this specific issue prior to the final decision, because the judge is sustaining those charges, and that is going to prevent our client from adjusting status, because the client is not an arriving alien. She was just paroled. So jurisdiction right now is with the immigration court. If we are able to overturn this judge's decision, then of course the client is going to be able, we're going to terminate removal, and then the client is going to be able to adjust status with USCIS. So we have to fight for it. We're not just going to give up because the judge decides to sustain those charges. We have to appeal because we do not agree with the decisions of the judge based on facts alone and based on the paperwork that we received and based on current case laws, okay? That's what exactly we're going to do. Because some people get released on parole, conditional parole, which is 236, under section 236, that's conditional, and that one will not allow you to do anything because it's just a conditional parole pending removal proceedings. This one was for humanitarian reason. There's a huge difference, and we have to make sure that we appeal, and so that the BIA can decide for us, and therefore we can change the course of this case. Otherwise, my client has to win asylum in order to be able to get a green card. And winning asylum is not a small piece of cake, right? You have to really, make sure that you have solid evidence and credible testimony and stuff like that. So we are going to fight for our client because that's what we do, and we do it with grace. We have been successful in most cases, especially when the facts are clear and the law is very clear. So we're just going to have to fight and see how it's going to go. I'm going to keep you updated on this. Again, don't forget to follow us on all platforms. Until next time, bye-bye.